rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are here this morning for oral argument in cause number CV18-0528, True North Companies LLC versus Jia Yi Lau. And am I pronouncing that correctly? Lai. Okay, long I. There we go. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, for your information, we have read the briefs. We have discussed this case in a conference and are familiar with the facts. You may proceed at this time, counsel.
Thank you, Your Honor.
I appreciate your time this morning. I understand that you've read the briefs and you've had a chance to talk about this case. I think it's a case essentially of first impression for the Arizona version of what's colloquially known as the anti-SLAPP statute. SLAPP, of course, being strategic lawsuits against public participation. And of course, they're codified at ARS 12751 and 12752. What is interesting about this appeal is I think it requires this court to specifically interpret what the legislature intended with this anti-SLAPP statute. And these two statutes are really the legislature's attempt to impose a different procedure for resolving certain and very limited types of potentially defamation claims or litigation actions that might proceed to chill public participation through the cost, if you will, of litigation. And when we look at these statutes, ARS 12752 is the portion of the statute that contains this new procedure, if you will. On the other hand, 12751 is the portion that defines when a defendant is able to employ the procedures that are set forth in 1272. So naturally, that creates a two-step process here. When a plaintiff files a lawsuit that the defendant believes is subject to 12752, it requires that the defendant establish that it is eligible to use the procedures in 12752 by meeting the definitional requirements that are in ARS 12751. And it's here where we find out what the legislature intended, and it's clear from the language here, and as you all are aware, that the requirement for the court in statutory interpretation is to first look to the clear language of the statute to determine what the legislature intended. And so when we look at 12751, what we find is the legislature intended a really small subset of cases.
Let me jump in.
Yes.
To what extent, I mean, you're suggesting that we need to interpret this statute. What in your mind, if any, portion of the statute is ambiguous?
I don't believe that any part of the statute is ambiguous.
So it's all based, we can read it as according and interpret to it according to its clear and plain language.
Right. Yes, I believe that the language is clear as to the legislature's intent. The meaning of those words is clear, and the ability to apply our facts to those words can be done. And so when we look at 751, the definition that is important here is, well, 752 says these procedures only apply to litigation or actions that involve the exercise of right of petition. That term is defined in 12751(1). And so we looked there to see what did the legislature intend, what did they intend to fall within that definition. And I'll submit the language is clear that there are 4 parts to that definition that need to be met in order to be able to take advantage of 12752. So the first part, and maybe the most important part, is that the statements that the plaintiff is complaining of being defamation in this case need to fall within constitutional protection of free speech. So that's the very first step of this analysis that the legislature required. Then and only then, if the court determines that constitutional protection is applicable, or in other words, that these statements are actionable or not actionable defamation, then there are 3 other components that need to be met, and all 3 of those components have to be met in addition to the constitutional protection. And those 3 components are: the first, it has to be a statement to a government agency or body, non-judicial, and certainly that would be met in this case because the statements were alleged to have been made before the Phoenix City Council. The other 2 is why we're here. The statements have to be made in relation to an issue that was under consideration before that body.
Counsel, to that point, there was a petition pending regarding the cultural center, is that not correct?
That is correct.
And the statements were made in regard to a petition that was before the council. Why do you believe that the statements made by Mr. Lay, wouldn't fall under the auspice of that?
Well, the first part I'm going to quibble with you, Judge Campbell, is there was a petition. It was a very broad petition that generically related to the Phoenix Cultural Center. But these statements were not made in connection with that very broad petition, and that petition got limited during the course of this hearing. Very specifically limited by the presiding member of the Phoenix City Council at the time, Mayor Stanton. And when this issue came up for consideration by the Phoenix Council, the language he used was very specific. He said, this is how we're going to proceed. We're going to have a motion that's going to define this issue. And then after that motion is made, then we will take public commentary, meaning that public commentary will be with respect to that motion. That's what defined the issue, not the petition. So yes, generally, any comments made with respect to the Phoenix Cultural Center would relate to the Phoenix Cultural Center.
Are you suggesting, counsel, that everybody else that spoke, I watched some of the meeting, but not all of it.
Okay.
But it didn't seem to me like others were staying true to the directive that they talk about the motion on the table. That we're still hearkening back to the broader petition. If you were to, how can you let this happen? And to get rid of the Chinese Cultural Center. This is not a great thing. I mean, am I wrong there? Or weren't people sort of all over the board?
Judge Brown, absolutely. And if you saw all of it, and I've watched it numerous times, yes, they are all over the board. But what's important to focus on is my client didn't sue any of them. They didn't make any comments that were defamatory.
Understood, but my point being, yes, the chair of the meeting, governs that meeting, so to speak, but when the agenda is broadly stated in the nature of a petition, you have 200 plus people there wanting to speak on that petition. I don't know. Is it really fair to say that they went beyond the bounds of what was on the agenda?
I think well, there are 2 different points here. Is it fair to say that they went beyond the bounds of what was on the agenda? That would be unfair to say because the agenda was extremely broad. I mean, it was a petition that, when it was made, wasn't subject to any limitations by the Phoenix Council. But when we get to the point of this testimony, it certainly was subject, and the Phoenix Council identified, here's the issue we're going to consider, and this is what we want the purpose of your marks to be related to. Now, just because they weren't related to that and the Phoenix Council allowed people to speak doesn't bring it within this definition of this statute.
So, Mr. Payne,
Yes.
you're obviously taking a very narrow view of what the term in connection with means, as it's stated in the statute. Is our statute based on a similar statute from another jurisdiction? Have there been cases interpreting that phrase if it's the same language? Or are we really writing on a blank slate here?
I believe we are writing on a blank slate. There are, I think, almost 40 states that have anti-SLAPP statutes, but none of them share our identical language. And for example, California is much more broad in terms of what the statements can relate to. For example, they don't necessarily require statements that have to be made in front of a government agency or body. So I don't know that we can take the interpretation of this part of the statute from other states. And I think, with all due respect, focusing on just this issue of under consideration bypasses the larger point that these statements weren't made within the confines of constitutional free speech after applying the tests that the Supreme Court required in Yetman v. English.
So really the starting point of your analysis is a presumption that these statements in and of themselves, unless they are otherwise protected, are in fact defamatory.
Yes.
So if Ellie certainly argues they weren't defamatory, and if we agreed with that, we wouldn't have to reach your analysis of the narrowness or broadness of that phrase.
Right. If you were to reach under the case law established by the Supreme Court that these are not defamatory as a matter of law, that no reasonable person under those tests could interpret these as being defamatory, then yes, we wouldn't get to, well, no, because then you would, I guess, argue that that's free speech protected by constitutional law. Then you'd have to get to the second part of this, which is satisfaction of all three, excuse me, of these elements. And let me just point out, we're talking about under consideration. And yes, you have the petition, but the Phoenix Council did very specifically identify what the issue under consideration was. And the reason that's important is because the last part of this definition requires that the oral statements were made with the purpose of influencing the city council on the issue of under consideration. And so once the Phoenix Council identified what we're considering, now these statements are moved away from the petition generally, but to the motion that was actually made.
Council, let's just talk hypothetically. Let's talk about this not in this context. Let's say we're talking about putting up a stop sign, and so a citizen gets up and says some very broadly offensive things about a council member in the context of their stop sign policy. Now, are we assuming that every citizen that gets up to speak is going to understand how narrowly drawn their protection is, and wouldn't that undermine the purpose of the statute in the first place?
No, I don't think so. Because
Explain how.
I think the purpose of this statute is identified by the language that the legislature specifically picked. And they actually put up a very high bar of the number of cases that this would apply to. And so it requires the defendant to actually satisfy every one of these elements, which really narrows the number of times we'll use this. So the legislature said the purpose of this statute is to really only find the very narrow set of cases that are truly frivolous and that are truly the types of cases where a plaintiff has brought it to try to run up the costs or deter speech in front of a public body with a absolutely frivolous lawsuit. Not one that's a close call, but one that arguably, even without this statute, would obviously get bounced on a motion for summary judgment because it just has no basis. And with that, I'll reserve the 6 minutes and 45 seconds I have.
Thank you.
Good morning, Your Honors, and may it please the Court. Fabian Zazweta on behalf of Mr. Charlie or Jai Lai. You can call him Charlie Lai. It's a lot easier to pronounce. Your Honor, before I begin our discussion, I'd like to address 3 prefatory comments. The first one here is just to remind the court that we're dealing here with a public forum and statements directed towards a matter of public concern. I think that's important because the First Amendment is deliberately broad in principle, and it applies to speech, to various types of speech that may be insulting, offensive, distasteful, and even more so when we're dealing with a matter of public importance. And I think that also promotes the citizens' participation to get involved in the as the amicus brief suggests, that citizens' participation in the governmental process. The last,
Counsel,
sorry.
help me understand that a little bit more. So you're saying that those broad goals that you outlined there nicely, how does that fit with defamation?
Right, so-
Have courts taken those two together and said, we're going to give a little more leeway on defamation, or we're going to be more strict to show defamation if it's meant to be matters that are talked about in the public square, so to speak? Can you point to case law that says that?
The first case I can think of, just the Madison case, which the trial court relied on. In that case, they dealt with, in my opinion, the trial court relied on specifically that dealt with a matter of public importance, and it was a public forum. So I think the trial court in this case saw that these statements were protected because they were on a matter of public importance on a forum open to the public. And I think the defamation or the First Amendment also ties to the issue of whether or not this is an exercise of right of petition. I think the statute itself is a procedural statute, but also substantive components that the trial court must utilize as the gatekeeper of whether or not a statement is capable of a defamatory meaning. And to that end, the trial court would analyze these statements in the context of which they were given, and not in such a narrow approach, but more so in the context and when they were stated, in this case in the public forum. So I think the trial court correctly held that the 6 statements were protected free speech. And looking over through the legislature's comments on the anti-SLAPP statute, the legislature intended or enacted the statute for an expedited and summary process of dismissal for cases such as the one before the court. And within that context, I turn to the first issue, whether or not the SLAPP statute was properly utilized. And in this case, I think it was. And as I mentioned, just because the first step is whether or not there's exercise of right of petition, which by definition means whether or not there's constitutionally oral statements that fall within the constitutional protections of free speech. In this case, the trial court is to analyze section 12-752B, all the evidence submitted by the parties, to determine whether or not there's a reasonable basis for Mr. Lai to make those statements. In this case, the trial court did that and reviewed all the evidence, the affidavits, or the declaration in this case, and determined that the statements were constitutionally protected. So the next step naturally follows is whether or not this is before a governmental body. This was. It's not disputed fact. And then after that, whether or not this was under consideration. We cited the Rydell case, not for precedential value, but the case that this court decided a few months ago, I believe in April, regarding the issue of whether or not something's in consideration. It should not split the hair too fine when we're dealing with the overall agenda item, which in this case is whether or not the city council should enact a measure that preserves the Chinese cultural community, or Chinese cultural center.
Doesn't that case have some of these potentially persuasive value for us?
It does, Your Honor, and that's why I filed the notice of supplemental authorities for persuasive value. Right.
You're just saying we're not bound by that.
No, Your Honor, correct. We're not bound by that, but I think it has some persuasive value in this case.
What about Mr. Payne's argument that Mr. Lai clearly went outside the bounds of the motion on the table? The motion on the table, if I remember correctly, was to authorize acceptance of funds to do a study, right? To do a historical study on the Chinese cultural center.
Correct.
That was the narrow motion, if you will, much more narrow than the broadly stated petition. What's wrong with Mr. Payne's argument that this clearly had nothing to do with that motion that was on the table. I don't know that Mr. Lai even referenced that.
Right, Your Honor, and that's because, so such a narrow, hyper-technical view on that specific motion, I mean, the court has to analyze whether or not, from a reasonable person's point of view, and the catalyst for the people to participate at this hearing, or at the city council, was the overall agenda item. It wasn't specifically to that motion. And I think in the trial court, the motion to dismiss, there's some case laws that was cited, or actually there was statement that there were privileges for individuals before city council that extended when the call to the public was already terminated. So I think, to answer the question, Judge Brown, if it's such a narrow focus view on that particular motion, I think we'll be sitting here, the courts will be filled with lawsuits because, again, this is from a reasonable person's point of view, not from an attorney's point of view who can analyze the situation and know what the exact motion on the table is. And I hope that answers the question. So under consideration, we've cited Rydell for persuasive value. The last prong of the analysis of the exercise of right of petition is whether or not it was made for purposes of influencing an action, decision, or result. In this case, keeping in mind the overall agenda item, which is the long-term preservation of the Chinese Cultural Center, the party to benefit from the demolition was True North, the appellant. So I think the court can at least determine how they proceed when it deals with that agenda item, the overall agenda item. Now,
Let's get to the statements themselves. There are 6 that are complained of, correct?
correct, Your Honor. The first statement is whether or not True North was the landlord here. We cited, the record below shows, in addition to the evidence that we submitted, the evidence shows that even the own spokesperson for True North, the True North in his separate lawsuit, their own attorneys referenced True North and 668 LLC interchangeably. And I think it's the statute, anti-SLAPP statute, is whether or not there's a reasonable basis for Mr. Lai to make the statement. In this case, there was, given the breadth of media articles, their own attorneys conflating both names, and I think there's a reasonable basis for Mr. Lai to make that statement. The second alleged defamatory comment was that True North only gave them 31 days to vacate the premises. In this case, we've attached the notice to the tenant. There's 31 days there, and it's disputed, but in context, there was an actual notice to the tenant that it gave them 31 days, and there's a reasonable basis for Mr. Lai to make that statement at that time, and again, in context. The third statement, the trial court referenced as hyperbole or puffery. They kicked us out. I think a reasonable person would interpret kicking us out as being taken out of the premises or locked out, and in this case, there's evidence that they were in fact locked out from the premises and could not return. Again, reasonable basis in Mr. Lai making that statement in context. The third statement was whether that True North's spokesperson made comments about my client's business, Super L Market, that they were bad business and they were essentially in bankruptcy. There's no evidence that they were ever in bankruptcy. The appellant cites to a case, the case was subject to another lawsuit, and it's my understanding that case has been dismissed to True North's benefit. However, I do not think the court should focus on that, as that case is still an ongoing litigation and is still subject to appeal. The third statement merits very little comment, as it's that True North stole Mr. Lai's forklift. Reviewing the video and the evidence, the trial judge correctly found that this statement was never made, that in fact he implied that they were prevented from receiving or going back and picking up their forklift, but he never stated that they stole the forklift. And the last comment was that the defendant was lying, and I think that can be interpreted as puffery, hyperbole, as suggested by the case law, and protected under the First Amendment. And another, I guess moving forward, I think if any more questions on the actual anti-SLAPP application. Okay, so the next issue I think before the court is whether or not there should have been leave to amend. And I think we cited various case law in California specifically because those cases have dealt with this issue. And those cases uniformly have held that once there's a showing that there's an exercise of right of petition, the opportunity to amend should be foreclosed because it's just a circular process and it kind of frustrates the purpose of the anti-SLAPP statute. And so I think the general rule regarding that issue, because I have not found any Arizona case law on this particular issue, it should be once there's a showing that there's an exercise of right of petition, in which there was in this case, the plaintiff or the SLAP plaintiff should be foreclosed or precluded from amending the complaint to avoid this whole process, or in other words, as the court in California noted, that they should be precluded from going back to the drawing boards to characterize their complaint when it would, so that it can satisfy or withstand the motion to dismiss under the statute. And even again, looking at the proposed amended complaint, there were just additional factual allegations. I think we would be here on a similar result, whether it be under the statute or under common law principles of the First Amendment. This also makes practical sense if they're permitted to amend the complaint every time there's a potential of being dismissed. This would defeat the purpose of the statute. This would be costly, burdensome, and this would be in contrary to what the legislature intended. And on that note, I have nothing further unless there are any questions. Great, thank you.
Thank you, counsel. Mr. Payne.
Thank you, Your Honors. Let me begin where that discussion left off on the motion to amend. Obviously, we have here in Arizona just a notice pleading requirement. And certainly the pleading in this case met that notice requirement. And then after this special motion to dismiss was filed, there was a motion to amend or leave to amend was sought on the basis of providing some more factual information in that notice pleading, and to correct this allegation regarding the stolen forklift, to add that it was the implication that it was stolen. Of course, that motion was denied, although there was no finding that it was futile, that there was an undue prejudice to the defendant in this case by bringing the amend, or that it was untimely in any sense. So that motion should have been granted. That obviously would have provided the trial court with some additional facts, and this court with additional facts to consider as it evaluated the defamation claims and whether 12751 should have applied. The court asked, is there some sort of procedure or case law that balances the concept of free speech and defamation? And certainly the Supreme Court addressed that in Yetman v. English, where they did exactly that. They did this balancing analysis to determine when cases should go to a jury, or when the court, as the gatekeeper, should determine that there is no defamation as a matter of law. Which brings up the...
But Yetman didn't involve a public meeting, in the sense, a government meeting with an agenda item. It wasn't the right of, it wouldn't involve the right of petition. Right? I mean, if I remember the facts correctly, what Mr. English referred to Mr. Yetman
as a communist.
At a private, well, I don't know if it was a fundraiser or whatever it was, but it was not a public governmentally.
Right, and so I don't think that issue is considered by the Supreme Court, nor
So which way
does
does
it.
that cut, is my question to you. Which way does that cut as far as, what about the argument that you should have even more broad opportunity, free speech protection, when you're in front of a public body, public, absolutely events that everything relates to the public square?
So let me address that in a couple ways. First of all, in the Yetman case, it was specifically addressing the issue of how do we balance the concept of free speech versus the concept that you're entitled to go to court to protect your reputation or harm to your reputation in the form of pursuing a claim for defamation. That wasn't in the public context, but why it's relevant here is we don't get to the public context until we first determine whether there's constitutional protection for this type of speech. That's where Yetman is important here. And so it's irrelevant that whether it was in front of a public body or not. Let me also add that this case has never been about whether somebody could come before the Phoenix Council in this case and speak. So Madison was about that issue, about whether a teacher had a right to even come to an administrative hearing and speak in front of that body. That's not the issue here. We're not trying to limit free speech or any speech in front of the public body. It's just down to what can you say once you get there. Do you have an absolute privilege to say whatever you want if it relates to some degree to the petition? And the answer there is no. And this court, a different panel in Rydell versus Fuentes, analyzed that. And in that case, they found that the petition did relate to the comments, but really carefully looked at what were the comments and what was in the petition. So for example, the plaintiff in that case, Rydell, was a developer. The petition was specifically about whether or not to approve her development. And so the comments about her related to that development that was subject to approval by the city council in Yuma in that case. We don't have that here. What this city council was looking to approve was whether or not to accept private money to do a historical preservation study.
And let's stop there for just one moment. When we look at the agendas are written, published, everybody knows what's been, that's not what was on the agenda, correct?
Correct.
It was limited during the meeting, is that correct?
Correct.
And so if it hadn't been limited, would your client have a cause of action? If the original agenda item had gone forward as planned, open, everybody come up and have your say, would your client have a claim?
Yes, absolutely.
Why?
Now, so first of all, the issue under consideration in your scenario would have been the agenda. But the comments still needed to relate to the issue under consideration, and that was to preserve the Phoenix Cultural Center. These comments had to deal with just a landlord-tenant dispute. They didn't have anything to do with preserving the cultural center. And then let's not forget about the very last element that's required under 12751(3). And that's the purpose of those statements have to be to influence a decision that governmental body is taking action on or trying to make. And in this case, the action that they were trying to do was the historical preservation study, but there is no action that the Phoenix City Council could have taken to preserve a private piece of property. And they also made that clear beforehand. So because these statements really didn't deal with the Phoenix Chinese Cultural Center other than that's where the property was located, these statements are about a landlord-tenant dispute, and my client wasn't even the landlord. But that's what these were about. Mayor Stanton actually acknowledged what you're talking about isn't the issue in front of us.
Do you agree that your client made public representations conflating the two entities?
No. So the evidence in this case suggests that Mr. Lai was responding, and his declaration says, the purpose of my comments was to respond to an article that came out September 6th. That article conflated my client with the entity that purchased 668 North, and it was based on a press release. If you look at the press release doesn't mention my client at any time. So no, my client didn't conflate it. The other evidence that they suggest to are statements made in litigation that occurred a month later than these statements were made. So certainly Mr. Lai didn't rely on that when he made statements about True North. He also admitted in his declaration that he was more than aware that 668 North was his landlord and not True North.
Thank you, counsel.
Thank you.
Counsel, we thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. We are at recess.
Thank you.